Greetings everyone. Allow me take you through a number of questions. Of course, these are business questions. Many of my students have reached out to me in regard to question approach. How one can approach legal questions. And it is important that we go through question approach. Of course, the questions I'm going to discuss are in regard to business law, procurement, and company law. Of course, they are for the benefit of both legal and business scholars. Question number 1. Discuss the elements of the law of contract. How would you approach such a question? What does such a question call for? When an examiner asks you to discuss the elements of the law of contract, this is how one can approach such a question. It is important in the approach for you to make sure that you define what a contract is. Then when you are defining a contract, you come up with a general definition of a contract and then the legal definition of a contract under the Contracts Act. Secondly, still under the approach, you will need to define the different elements of the contract. And you will define the different elements from the Contracts Act. Thereafter, you will go to the main subject of the question, and that is for you to discuss the different elements of the contract. And after discussing the different elements of the contract, you come up with what we call conclusionary remarks from your own perspective. So I want us to make an attempt of answering the above question in regard to the approach which we've just talked about. That you will define what a contract is under the Contracts Act, and that is how a contract is defined. That a contract is defined under Section 10 of the Contracts Act 2010, which states that it's an agreement made with the free consent of parties with capacity to contract for a lawful consideration and with a lawful object, with the intention to be legally bound. That is how an agreement is defined under our laws. Then when we go to the different elements, you are expected to define an offer. And an offer is defined under Section 2 of the Contracts Act. That an offer means the willingness to do or to abstain from doing anything signified by a person to another with a view to obtaining the assent of that other person to the act or abstinence. So that is how an offer is defined. And definitely after defining an offer, it is important for us to know what constitutes a valid offer. And this is reflected upon under Section 3 of the Contracts Act, which talks about a number of things. One, that an offer must be specific or definite. That an offer can be made to the general public or a class of persons. And that was discussed in the case of Khalil versus Carbolic Smoke Ball Company. And then the other element of under the law of contract is acceptance. And acceptance is still defined under Section 2 of the Contracts Act to mean an assent to an offer made by a person to whom the offer is made. What constitutes a valid acceptance? This is taken note of under Section 7 and 8 of the Contracts Act. And this includes that the offeree must be aware of and must have intended to accept the offer when he did what is alleged to be the acceptance. And 2, the offeree's assent must be notified or made known to the offerer. And that is in the case of household fire insurance, company limited versus grant. Number 3, an offer made to the public in general can be accepted by any person who fulfills or performs the conditions stated in the offer. Number 4, acceptance of an offer must not be unconditional, or must not be conditional. But acceptance of an offer must not be conditional. The moment it is conditional, then it ceases to be an offer. And another one, an offer made to a particular person can only be accepted by that person and not any other person to whom it has not been made. Number 3, the third element under the law of contract is the element of consideration. And consideration is also defined under Section 2 of the Contracts Act 2010. But consideration means a right, interest, profit or benefit accruing to one party or forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other party. And that was discussed in the case of Curie versus Lisa. Then what constitutes a valid consideration? Of course, consideration may be executed or executory. Consideration must be sufficient or real, but it need not be adequate. And then consideration must not be past. So briefly, that's how such a question can be answered. Of course, there are so many cases which you can add in, which explain the different principles which I've talked about, and also there are other principles which you can also be able to discuss. But that is how one can be able to approach and also answer that kind of question. Question number 2. How can an offer be terminated? Of course, this is a straightforward question. And how would you approach such a question? You begin by defining an offer. And that is under Section 2 of the Contracts Act. I think it is Section 2. And after defining an offer, you also define termination. What amounts to termination? Or what is termination in general? And thereafter, the student will be called upon to discuss the different ways of termination. Resolution. Section 6 of the Contracts Act stipulates the different ways of termination. Of course, these will come in after you, still under the resolution, having defined what an offer is and having defined what termination is. Then thereafter, you will go to Section 6 of the Contracts Act, which stipulates the different ways of termination. One of them is through communication of the notice of revocation by the offerer to the other party. The other one is lapse of time prescribed in the offer. The other one is failure of the acceptor to fulfill a condition precedent to acceptance. And thirdly, death or insanity of the offerer. And then question 3. Discuss the principle of lifting the veil of a company. Of course, this is a question that is asked almost every legal student who has gone in for business law, whether legal or business scholars. This is a rich question which can come in an exam at any point in time. Discuss the principle of lifting the veil of incorporation. How would you approach such a question? You begin by defining a company. You begin by stating the general definition of a company, and thereafter you define a company from the Companies Act 2012. And thereafter you discuss a case on corporate personality. A case which explains what a company becomes after incorporation. And the leading case there is the case of Salmon versus Salmon. Of course, when you're discussing it, you begin by stating the brief facts of the case, a brief summary of what the case was all about, and thereafter you bring the holding of the case. And in particular, you'll have to limit yourself to what the judges stated when it comes to corporate personality, which is to the effect that a company upon incorporation becomes a body corporate distinct from all its members and shareholders. So after bringing in that case, one will have to discuss the principles, the principle of lifting the veil of incorporation, and thereafter he or she will come up with conclusionary remarks. A brief resolution. Of course, you can see from the resolution that I began by defining what a company is. That is from the Act. However, it is important for you to begin with the general definition. So thereafter, I brought in the case of Salmon versus Salmon and what it talks about. And thereafter, I went to the definition of the principle of lifting the veil and what it is all about. And basically, lifting the veil is about disregarding the company's corporate personality to look into the affairs of the company and the people who are involved in the running of the company. Why? To check what they do, whether they follow the objects clause of the company, and in the event that there are any deviations, then they will be held accountable. That is what lifting the veil is all about. And then the fourth question is for the student to state the different circumstances under which a company's corporate personality may be disregarded. What are some of those circumstances which may lead to a company's corporate personality being disregarded? Of course, this is the same as lifting the veil. Why should court dispense away with the company's corporate personality? But of course, these circumstances can be got from the Companies Act, but include, of course, this is a straightforward question, and the approach would be for you to state the circumstances, which circumstances include where the number is below the legal minimum, where the company is not mentioned in the bill of exchange, holding and subsidiary companies, reckless or fraudulent trading, investigations into related companies, where the shareholders of the company use the company as an agent. Of course, extra marks can be given to a person who quotes sections and also quotes cases. So briefly, those are some of the questions and their approaches. Very important. Thank you.